Well, good evening. Happy Friday to all of you. I apologize for being a little bit late this evening. It was a combination of factors. One, I don't know what happens to people on the roadways when the sun starts setting a little bit earlier in the day, but they apparently just all lose the ability to function as drivers and, again, participating members of society on the roadways. Two, tech issues. For the first time in a little while, I had to do a restart of the computer before getting live stream going. But we're here. We are here, and we are recapping the case of Kowalski versus Johns Hopkins All Children's Hospital. Now, we've been recapping this trial as it's been going forward, and let's go ahead and do just a summation. So the trial itself involves Maya Kowalski, at the time a minor, who was admitted to Johns Hopkins All Children's Health. Then, while she was admitted, Department of Children and Families initiated an action to have essentially the court in Florida enter a dependency order, a shelter order that removed Maya from the custody of her parents. Various allegations as to why. The child was diagnosed with CRPS. The hospital contended that it was actually Munchausen's by proxy. Well, that resulted in a back and forth within the dependency court that, unfortunately, the conclusion of that was on January 7th. Maya Kowalski's mother, Beata Kowalski, took her own life. Shortly thereafter, Maya was released from dependency custody, and everyone acknowledged CRPS, and now we have a resulting lawsuit over whether the hospital acted improperly in their treatment and care of Maya, and whether they falsely imprisoned her against her will when acting either before or after the dependency order was entered. In the context of after the dependency order was entered, it's whether they acted in conformity with the order. Then there's additional causes of action, intentional infliction of emotional distress, etc. As I kind of indicate at the beginning of every one of these streams, the subject matter we talk about in these recaps is highly sensitive. We deal with children with chronic pain, and we talk about allegations of CA. I have to use the acronym because of YouTube, as well as, unaliving. Again, I have to use the acronym. I have to use a different word because of the YouTubes and the YouTube gods. So I do run a rolling banner so that people that join the stream are aware that we're talking about a subject matter that's rather sensitive in nature. And we're not recapping today because today there was no court. We're recapping yesterday, Thursday. I had other obligations, wasn't able to do a recap that evening. I had to play catch up on what actually transpired in court yesterday. And it was 2 depositions that were played in court and a lot of argument. Now, a lot of this is really relevant because Maya takes the stand on Monday. Maya takes the stand on Monday afternoon. That's the anticipation of the plaintiff's counsel. And a lot of the motions argument was getting in groundwork for when Maya does eventually take the stand. As always, we kind of begin with some of the things that happened beforehand as we lead up to that hearing. Let me make sure that I've got the sound boosted because court coverage is always low in volume. Make sure I've got that before I added the stream. I did turn on closed captioning so that you guys can see and monitor via closed captioning. And let's see. 1 second. Let me make sure that my volume is adjusted so it doesn't blow my eardrums off. And for those of you wondering why I'm covering this case, why are we listening to this person on the screen talk about this particular case? Well, I'm a domestic relations practitioner. I'm an attorney that practices in the area of domestic relations litigation, and I've been doing so in the Commonwealth of Virginia for more than 10 years. So this case has a lot of overlap with cases that I run into in my everyday practice. Coupled with that, we've got personal injury claims, etc. And there's been a lot of people watching the case, but not a whole lot of people discussing the trial itself. And I've been trying to break down some of the motions, what we're allowed to hear, not allowed to hear, and some of the strategy calls that are being made throughout the proceedings. And I do see people in the question, or rather in the chat, asking questions. How old is Maya? Maya at this point in time is 17 years of age. When she was first admitted to the hospital, I believe she was, I want to say 10. She was 10 years old. 10 years old, because this stems from allegations in 2015 leading into 2016. the trial has been delayed substantially. Take Care of Maya, as the trial is referred to, is the Netflix documentary that documented parts of this particular case. And a lot of people have a lot of interest and not a lot of understanding about what's going on in the actual trial itself. We're navigating a tightrope, as I've been saying, between DCF orders, etc. Site stream is going to be a little bit shorter than the usual 2 hours I've been covering these things, because I do have an evening show on Fridays, Friday Night Frenzy, recapping some of the stuff in law. And we had a few things in law, including one of the cases I've been covering quite closely, Sam Bankman-Fried going to trial. So if you guys want to stick around towards the end of the stream, it will redirect into Friday Night Frenzy. I'll probably take a 15-minute break in between this stream and that. Why do I break the streams up? Because Friday Night Frenzy is supposed to be lighthearted and fun. This particular case and this subject matter, while we get little moments in court that are funny, the subject matter is a little bit more sensitive. And I want to make sure that I'm covering it, and I'm covering it the way that I would explain these things as a family law practitioner. So without further ado, thank you, Jules. Jules is ears and eyes on the ground. She's been in trial, I think, every single day, monitoring kind of what's going on, observing what's going on. And Jules, we're going to get to a point in the deposition, and I'm going to have a very interesting question for you. And I think you know what the question is, because for those of you who follow me on Twitter, the handle is Lumber Law, by the way. I posted a snippet from yesterday's depositions that were played in court. And to say that I was surprised by what I heard is an understatement. When we get there, I'll probably give a profanity warning before I go into that coverage. So without further ado, let's go ahead and get into the testimony from yesterday. Like I said, closed captioning is on. I'm going to try and move this guy so it's not too much interfering with our view of what we're watching. Hey, go up there. Hey, closed captioning, behave, stay up there.
Take off.
Either way.
I'm fine with that.
Thank you, Your Honor.
Is there any objection from the defense on Dr. Newberger appearing by Zoom if he gets well enough to do that?
No, sir.
So he could appear by Zoom.
Right away, we've got a caveat. So you guys remember that I'm going to say yesterday quite a bit. When I refer to yesterday, if I say yesterday, I'm referring to day 9 of trial, which was in fact Wednesday. On Wednesday, day 9 of trial, there was a brief interlude where the judge called up Mr. Anderson and Mr. Hunter, lead plaintiff's counsel and lead defense counsel, to the bench and relayed a document to plaintiff's counsel, and defense counsel began consoling the plaintiff's counsel, as did the court. It looked that plaintiff's counsel was relatively taken aback by that, and we were kind of contemplating what that might have been. I shared a personal story about things that have happened to me in court before. But it appears that at least part of a dilemma that plaintiff's counsel is running into is one of their primary doctors, Dr. Newberg, who's supposed to be an expert testifying on their behalf, is hospitalized. I'm not going to say that could have been the only thing, but that is possibly one of the things that's being discussed, that was being discussed. In either event, when a doctor or when one of your expert witnesses has been hospitalized during the middle of trial, a trial that you've been waiting to try for several years, it can throw a wrench in your proceedings. So the court explains that they're going to allow him to testify via Zoom, and then they get into kind of the depositions.
Pending his health, but
If he's not sitting in a hospital room, is that what you're telling me?
currently, but I'm hoping that over the weekend he gets better. That's all.
He's at Mass General, and he is in a hospital room. He's having testing
On national TV.
Yeah, I knew that was going to happen, so I did a quick little fast forward. Mr. Anderson kind of makes a little statement about what he might be undergoing as far as treatment, and I don't want to air that on national TV. I don't want to rebroadcast that. That's his personal issues. I'm not going to rebroadcast it, but he is hospitalized.
Sorry about that, Dr. Newberger.
Okay. Anything else? Can I bring in the jury?
Are we set up?
We will be playing Rebecca Johnson first.
And I'm assuming, Mr. Reyes, you're going to be able to play it. Looks like all the screens are on. And everyone Yes.
There's Jules. I see you,
Sign
Jules.
or
Jules is right back, but behind the gentleman, it looks like Clark Kent. Oh my gosh, it looks like Clark Kent. Jules is behind the gentleman looking like Clark Kent today. So everyone wave at Jules.
Good work.
Good.
Let's bump this to 1.5. That's Mr. Kowalski, Jack Kowalski, Maya's father.
All right.
do you want to practice it for a second to see if it's okay? Okay. Are we ready to go?
I'm going to do a quick audio test, Your Honor, so we don't do that to the jury in here, if you don't mind.
Sure. Mr. Reyes, are you okay?
Yes, I'm fine. May I display just the
In comes the jury. The judge gives an instruction. I'm going to take a pause after the instruction to kind of explain because people have questions about
I want
depo.
to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And since you were last here, has anyone approached you about this case? And since you were last here, have you seen any media accounts of this case? Thank you very much. Now, let me tell you, this morning, you're going to see two different depositions. We're going to take a break after the first deposition, and then you'll have the second deposition later on this morning. The deposition is sworn testimony of these two witnesses that was given before trial, and it will be presented to you this morning. You are to consider and weigh this testimony as you would any other evidence in the case. And with that, let me figure out how to turn this lights on.
Go into real time because this part's kind of funny.
Are you able to see?
Not very well. I want to disagree with the judge, but
There's like 9 buttons.
Mr. Anderson wearing quite the tie today.
Okay. If that is too much light when we start playing the depositions, let me know and I'll keep pushing buttons. Okay, Mr. Anderson, who are we having first, please?
Rebecca Johnson. Rebecca Johnson.
Thank you. Mr. Reyes, you may start the movie.
Thank you. Will you raise your right hand, please, Ms. Johnson? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. I guess I'd like to start with if you could give me your professional name and professional address for the record, please.
Sure, it's Rebecca Johnson. I'm an LMHC licensed mental health counselor. I'm the owner of Restoration Counseling in Cape Coral. It's 1222 Southeast 47th Street, Suite 215,
Okay. And when did you begin restoration counseling approximately?
March of 2017.
Okay. And my understanding is that you have seen Maya Kowalski, Kyle Kowalski, and Jack Kowalski at Restoration Counseling from when you opened it to the present day, correct?
Yes.
And my understanding is you've recently had some visits with Maya and Kyle as recently as November of this year. Is that correct?
Correct.
Prior to Restoration Counseling, where did you work?
At Eagles Wings Counseling Center in Venice.
And how long were you at Eagles Wings Counseling Center?
I was there 3.5, 4 years.
Okay. Well, and approximately when did you start at Eagles Wings?
Thinking back. Probably February 2014-ish, somewhere around there. That's when I graduated with my degree. So I started my internship with them.
Okay. Well, let's talk about that. Can you give me the benefit of your education and training, starting from the time that you graduated high school and moving through all degrees and education obtained through to the present day?
Okay. I graduated. You want the date of when I graduated high school?
You can approximate it. It's fine. Like I told you, it's not a memory contest.
I graduated high school, and then I graduated with my 4-year degree in 1998 in psychology. And then I went back to get my graduate degree in 2011.
So you went back to get your graduate degree in 2011?
Right.
It is 15 minutes into a live stream. 15 minutes into a live stream, and I've muted myself again. 15 minutes, Rob. That's a record. That's a record. Oh, Elaine, microphone. Okay. So while the chat calms down and realized that I'm muted, and yes, I did see notes about how I can make it a little light. There is a little light that shows me. I just can't really see it. Anyways, I'm going to go ahead and remove the closed captioning. And even though the banner that was up kind of shows people who's testifying, I think it's more important that people see the transcribed testimony of these witnesses that are appearing by deposition. So I'm going to go ahead and remove that banner. So the bottom of that, you can see the transcription of the answers and the questions. Now, a lot of people had questions beforehand. I'm going to try to answer those kind of as quickly as I can. Depositions. Why are we listening to depositions at trial? Various reasons occur. Some are strategic, some are availability. One of the witnesses that are going to be called had an unfortunate passing, so the only thing available is the deposition to play to the jury. So the depositions are taken during discovery phase of this trial, and they're done to gain information. But in most instances, what we do is we take depositions via video feed, so that in the eventuality that someone is not available to testify at trial, especially a big trial like this, that we can play the video if we need to. Why are we watching a deposition? Well, what are depositions at trial? And you guys have heard previously deposition designation. So what that is when a plaintiff or a party decides they want to use a deposition at trial, the judge then has to rule on the various objections that were made during the course of that deposition. Depositions are conducted a lot like trial with a big caveat. There's no judge there to rule on objections and tell you what can or cannot come in. So when we conduct depositions, we're oftentimes it's like a dogfight. You've got attorney for the party, attorney for the other party, and oftentimes an attorney for the witness. People asked who that woman sitting on the right hand side of the table was. That's Ms. Johnson's attorney. She's present to assert any objections on behalf of her client that might come up in the course of the deposition. And then there's attorneys for the plaintiffs and attorneys for the defendants that are on the Zoom call conducting the deposition. So when we want to submit these at trial, we have to whittle them down. We have to get the judge to make specific rulings on the objections, because we don't want the whole testimony to be played, because like in court, we're making objections to different questions that are hearsay or call for a conclusion that they can't make or are leading in nature. So we object during the course of the deposition. And we say, objection to the form of the question, you can continue to answer. Unless we get to a subject matter where we believe that we have the ability to stop the depo, at which case we object, oftentimes rather emphatically and loudly. We object and we say, I'm instructing my client not to answer, or I'm instructing the party not to answer. That's basically drawing a line in the sand. If the opposing party or counsel wants to cross that line, they can call a standing judge at the moment to have them rule in the interim, or we can suspend the deposition and recall it at a later date, pending the outcome of that particular ruling. There's no judge present. So it's a lot of grandstanding by the attorneys during these, and there's a lot of whittling these things down before trial. So when we want to submit the designation at trial, we have to give the judge the full transcript, our objection, and then an explanation of our objection. Then during the course of the trial, the judge and the attorneys argue back and forth over whether certain portions of the transcript should be cut, certain videos should be cut, and then we're editing the video to be played by the jury. Because it's a video. You can't really unring a bell when a video is being played. So that's kind of an explanation of this. So Rebecca Johnson, they decided to do by deposition designation. And I'm going to do this. There's not a whole lot in her depo, except for a couple of different caveats. She treated Maya for depression, anxiety stemming from both her CRPS as well as certain trauma. There's bullying that's being discussed, etc. From this deposition, I actually took more points for the defense than I did for the plaintiffs. The plaintiffs got in that Maya was being treated because the plaintiffs, and there's recommendations on continued treatment and therapy because they need to do that to establish damages. Part of the cause of action here is intentional infliction of emotional distress. When you do that, you have to give the jury an adequate understanding of what is required to compensate the person who was harmed by that intentional infliction of emotional distress. And oftentimes that requires ongoing therapeutic treatment. So you need an expert to testify to how much therapy is going to be needed by this particular individual because of the harm that was caused by the defendant in this case, the hospital. So that's one of the things. Now, what I did hear in this that was favorable for the defense was that a lot of the treatment that was being given to Maya prior to she was being treated throughout, but a lot of the treatment that was being given for depression and anxiety before her hospitalization. So Maya was being treated for depression and anxiety before the hospitalization. And the hospital is going to argue that because she was already being treated for these things, that the existence of depression and anxiety after the hospitalization doesn't mean that she should be awarded or compensated for that. That's what they're going to argue. Whether you believe it or not, that's what they're going to argue. And Ms. Johnson, I think, testified fine. I didn't see a whole lot of really good examination here, with one glaring exception. And I cannot imagine, and I've got speculation about the question I'm going to fast forward to, because when you listen to it, I want you to listen to how seamlessly it is with these depot designations. When you watch them, there's a lot of cuts that feel kind of unnatural. And at this particular instance, there aren't. So I don't think there was an objection lodged to the question, because I think that it was a calculated strategy not to make an objection, because at this point in time, defense counsel is asking the question. So, and yeah, I did see that, Jules. Jules makes the point the jurors were taking notes during the deposition. I imagine that they were. They took notes throughout both depositions, and they actually had questions for the judge. The jury in this particular case has been able to ask questions of the witnesses at the conclusion of the examination by the plaintiffs and the defense. With the depots, they're not able to, and I was wondering how the judge was going to handle that. We will get to that at the end of the depot, but I imagine that there were a lot of questions, and the judge can't answer them because the witness isn't there to answer the questions. The judge can't fill in the place for the witness. A lot of you guys already know where I'm going with this. Yeah. 1:15:32. 1:15. We'll start at 1:15:02. This is a warning. This is a warning. This is going to feel really not okay. And I'm going to have a whole lot of thoughts, and I'm giving you a warning because I'm probably going to lay those thoughts filled with profanity, even though it's not been 2 hours. Hopefully YouTube doesn't get too upset about it.
Of CRPS?
To my knowledge.
Do you hold yourself out as an expert in the treatment of CRPS?
We're going to slow this one down to 1 normal speed.
Yes. I believe Maya was your first pediatric CRPS patient that you treated, correct? Correct. How many other patients before Maya, whether they're adult or pediatric, have you provided services for that had complex regional pain syndrome? None. I think you were asked by Mr. Anderson whether mom did everything that she could to help this child. Do you recall that question or some variant thereof?
Yes.
Is it your opinion that maternal suicide is helpful to a child?
No, that is not helpful.
Why is it not helpful?
The trauma of the grief.
What is your understanding of why Maya's mother committed suicide? Or do you not have an opinion on that either way?
My understanding is that Beata felt that because the allegations were against her, she was what was keeping her child from coming home.
Okay. And who provided you with that information?
The family.
I am muted again, but that's fine. They knew this was being recorded. We're replaying that. What were they thinking? What were they thinking? Why? Why? Why ask the question that way? What was going on in that attorney's head at that moment? I understand vigorous advocacy for your client, which is the hospital. I understand how that question, given how a jury is perceiving the evidence being taken in, I understand how that question might be beneficial in some very rare cases. I understand why an attorney would want to ask that question. People asked me, why did she smile? Because the question is ridiculous. It's ridiculous on its face. And I understand that people might have the position in a trial that, yes, what Maya Kowalski did was ultimately not in her child's best interest. And if her child had a say in that moment, she would say, Mom, don't do this. This isn't good for me. I understand that logical position. There's a logical statement there. But holy crap. What the hell were you thinking? What were you thinking? So why smile? Because the question is ridiculous. It is ridiculous. This was Maya's treating therapist. It's ridiculous. I'm sitting there going, oh my God. And you know why the plaintiff didn't object, because the plaintiff's going, she can answer the question.
I think you were asked by Mr. Anderson whether Mom did everything that she could to help this child. Do you recall that question or some variant thereof?
Yes.
Is it your opinion that maternal suicide is helpful to a child?
No, that is not helpful.
Why is it not helpful?
The trauma of the grief.
Now, I also caught a mistranscription here. This was something that's kind of bothered me a bit, because this is the transcript that they agreed to. I listened to this thing several times. She clearly says the trauma and the grief, but the transcription says the child has to grieve. It's not what she said. That's not what she said, which is also one of the risks of depositions and transcription. People, even though they're charged with transcribing things accurately, it doesn't always happen. But I have thoughts. I was driving my car when I heard that, coming back from court. People are asking to play that last part again. Okay, listen to the last part. I'll replay it. It warrants being replayed, because what the funny business.
Did everything that she could.
Yo.
I think you were asked by Mr. Anderson whether Mom did everything that she could to help this child. Do you recall that question or some variant thereof?
Yes.
Is it your opinion that maternal suicide is helpful to a child?
No, that is not helpful.
Why is it not helpful?
The trauma of the grief.
What is your
Jules, is that right? Well, good. My thumbnail is even more appropriate now. The attorney in my thumbnail has his head in his palm is Hughes, lead counsel for the hospital. So a couple of things. One, did you guys hear the trauma and the grief? But in the transcript, it says the child has to grieve. Mistranscription. That's a problem. I would have a problem with that, because And I wonder how, if anyone in the jury caught that. I don't know if they did or not. It doesn't really bother me one way or the other because they're listening and they're supposed to take the transcribed testimony as the testimony, but it clearly says the trauma and the grief. But it's transcribed differently. If Mr. Hughes is the one asking those questions, he must not have had very many trials in front of a jury, because that question would have never left his mouth. No matter how you are viewing the facts at this point in time, once you do that in a deposition, you cannot control how that's going to be used. That was so stupid. That was so dumb. If you have one juror who was sensitive or who has lost anyone to unaliving, that one freaking question might have lost you the case. That one question might have lost you the case. Just, what the hell were you thinking? Because jurors are humans. We ask them to disconnect when we give them, or when the judge gives them jury instructions on how they're supposed to interpret the law and the facts and apply the facts to the law as instructed by the judge. But you think there's not a juror in that box who didn't hear that question and cringe? Oh my God. Oh my God. And what's worse, that was the last question. It's not some question in the middle of the deposition. It's not some question in the beginning. It was the last series of questions. So, Mr. Hughes, you put an exclamation point on your deposition. It just might have been in the wrong column. And I imagine that there were some arguments over whether this would be allowed to be played. And I imagine defense lost every one of those arguments because it was defense's own question. What a misstep. And when the plaintiffs had that in their possession, holy smokes. I was without words. And I immediately texted all of my lawyer friends. I was like, you have to see this clip. You have to see this clip. The hell were you thinking? The hell were you thinking? How was this going to be good for you in any sense of the word? We'll finish so you guys can hear that this was the last series of questions.
Your understanding of why Maya's mother committed suicide? Or do you not have an opinion on that either way?
My understanding is that Beata felt that because the allegations.
I'm being informed we have a lot of new viewers. We're going to back up because this one, for the people who are curious about this particular trial, I've been covering this trial, the case of Maya Kowalski versus Johns Hopkins All Children's Health. And what you're about to hear, to the new viewers who are here from, thank you, Eric Hunley and Mark Robert for doing that redirect. You guys are awesome. For you guys who are just joining the stream, you're about to hear defense counsel for the hospital ask a question to Maya Kowalski's treating therapist at this particular time. The defense attorney for the hospital is about to ask a question, and I kind of want to get your guys' unvarnished reaction to the question asked and recognize that the jury is listening to this, watching this. There is no redirect. There's no curative instruction. This is what they're watching. It's the last set of questions in this particular deposition designation. And again, by the hospital to Maya's treating therapist.
I think you were asked by Mr. Anderson whether mom did everything that she could to help this child. Do you recall that question or some variant thereof?
Yes.
Is it your opinion that maternal suicide is helpful to a child?
No, that is not helpful.
Why is it not helpful?
The trauma, the grief.
What is your understanding of why Maya's mother committed suicide? Or do you not have an opinion on that either way?
My understanding is that Beata felt that because the allegations were against her, she was what was keeping her child from coming home.
Okay. And who provided you with that information?
The family?
Okay, members of the jury, that concludes the first deposition. We're going to take a break.
Jack Kowalski knew that was coming.
We'd like to publish some to the jury before we take a break.
Is it short?
One page.
Is it in
Jack.
evidence?
It is.
Then yes, you may.
Thank you. Could we see it, please? No.
He's about to publish a letter that was written by that therapist to the hospital. Jack Kowalski's response at the end of that plaintiff deposition, he had a little baby smirk on his face. It's not because of what he heard. It's because he knows the impact of what was said. He knows the hospital asking that question was the dumbest thing they could have.
There's
This is a drop the mic.
question of the deponent who's not here, or is it a question for me? Okay. Are we okay to publish what Mr. Whitney wanted to publish?
Yes, sir.
Okay, Mr. Whitney, you can go ahead.
So it's a to whom it may concern letter regarding the improvements that Maya has made October 21st, 2016. This is after Maya's mother had taken her own life. Oh no, this is 2016, October 16, 20. This is before. This is before. For those of you who want me to read it, okay. To whom it may concern, Maya Kowalski began counseling with me November 9th, 2015. Originally, Maya began therapy because of her difficulty dealing with medical diagnosis of RSD. Most recently, I've been treating Maya for depression as a result of her physical limitations of RSD, as well as the distress she feels because of her current circumstances, which include school and social settings. I've observed significant improvements in Maya's mood. I believe that Maya's parents, Beata and Jack Kowalski, have played a large part in Maya's progress. Each time Maya came to see me, I perceived nothing but love, care, and devotion toward her from her parents. In the beginning of the counseling process, as well as the following occasions, I have met with Beata or Jack individually to receive updates regarding Maya's situation. Again, I witnessed deep concerns and faithful carefulness regarding their daughter. In addition, I've met with Kyle Kowalski since March of 2016. Counseling for Kyle focused on how his sister's condition has affected him. Yet again, in every meeting with Kyle and his parents, I experienced responsiveness and attention on behalf of Kyle and Maya. In my opinion, Jack and Beata are attentive and caring parents. I've never felt that either has jeopardized or put Maya or Kyle at any harmful risk. I understand Maya's medical treatment is complicated, and I believe her parents have done everything they can in order for their daughter to be well. Sincerely, Rebecca Johnson, registered mental health counselor intern. They go on to her credentials. They try to attack her credentials. It doesn't do a whole lot. It was the question itself. It was that question. So that was asked, and yeah, my timing was wrong. So 2016. So Beata Kowalski took her own life January 7th of 2017. So the dependency action was October 13th was the removal order of 2016, and January 7th, 2017 is when Beata took her own life. So this was a letter that was written after the dependency action for purposes that it would be read to support the Kowalskis. So this is correct, Gwendolyn. They already they went through it. They did the cuts necessary before it was played in court. Those were post objections. That was played. That was either agreed or ruled upon. So let's fast forward to the next deposition, which a lot of people have been waiting to hear. And I'll explain why this is occurring by deposition, not in person. Entering.
Affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Catherine R. Bedy.
Good. And where do you work?
I work for Johns Hopkins Children's Hospital.
And what is your position?
I'm a pediatric intensive care licensed clinical social worker.
Have you been disciplined in any of your jobs?
Yes.
Right. Have you been disciplined in any of your jobs?
Yes.
All right. Tell me where and why.
I was disciplined at John Hopkins for yelling at another coworker.
And what was the consequence? Were you
It was just a written.
a write-up,
Yes.
basically? What happened there?
I'm not sure if I understand the question.
You guys got into an argument?
Yes.
Okay. But whatever happened, Johns Hopkins felt it was necessary to write you up.
That's my understanding.
Okay. So in any event, after that discipline, were you subject to any retraining of any kind?
No.
And obviously you were not fired.
Correct.
What was the name of the person that made the complaint against you?
Her name's Pam. For the life of me, I don't remember her last name.
And what was her position?
She was a case manager in the cardiac care unit.
What's a case manager? Is that another social worker?
No, case managers.
A nurse?
No. Well, she is a nurse, but they work to coordinate discharge for medical equipment, medications, home nursing. They work to help discharge patients to rehab centers.
And what was the essence of the dispute?
Yeah.
Here, let me show you. Maybe I can help you. I'm going to show you Exhibit 3 for the record.
Okay.
And what is that date?
11/18/2016.
2016. 11/18/16.
Yes.
So this was during Maya's stay?
Yes.
Okay. And what happened? Were you complaining at the time of covering more than one unit, if you will, or floor?
Yes.
At that time, were you covering more than one floor?
I was covering 2 units.
What units?
The pediatric intensive care unit and the cardiovascular intensive care.
We're going to fast forward a bit. She was the licensed social worker that was contracted. She actually worked for the hospital directly. A lot of when you hear Cathi Bedy in the testimony, this is the Cathi Bedy they're referring to. Like I said, this is the Cathi Bedy they're referring to. Now, fast forwarding to the next little bit. Oh, and she starts checking her cell phone. Yeah. 1:50:31. Don't check your cell phone during a depo. Recognize that depo might be played in court. Treat it with professionalism. The jury is giving observation to her appearance. They're giving observation to her appearance. If you are trying not to be perceived by the jury, the eventual trial, as a walking something on wheels, maybe don't act that way. Oh, I caught that rather emphatically. She was wearing a cross. For those people asking why would they play the deposition of Cathi Bedy and not have her called, I'll answer that in a minute, but I want you to think about how the jury's perceiving this version of Cathi Bedy versus what version would have showed up had they called her live.
This child's operating diagnosis include complex regional pain syndrome.
Her diagnosis included that, yes.
As soon as this child, the medical doctors, not you, hospital determined in the chart that she did have complex regional pain syndrome, that invalidated any allegation of Munchausen's by proxy, correct?
That was not a determination for me to make.
Well, you said that you read up on it, right?
On Munchausen, correct.
And you did recommend on multiple occasions that the child be kept in the hospital, did you not? I just read it to you.
Yes, yes, I did.
And on multiple occasions, you made recommendations to keep the mother away from the child, did you not?
Yes.
And on multiple occasions, you made recommendations to limit the child's contact with certain family members, including the father, did you not?
Yes.
All of the things you were doing were based on a presumption that there was Munchausen's by proxy going on with his family, right?
Not my presumption. At that point, she had been sheltered, and I had to follow the shelter order along with the visitation orders that were given by the court. I made recommendations based on how Maya was participating in her therapies and with the staff.
Isn't it true you were the person in the hospital that had the primary control over who saw Maya, what Maya ate, what she did, who she could talk to?
No.
Okay, who else in the hospital, after reviewing all of these emails and memos we're about to go over, who else had day-to-day control over who Maya could see and not see, and who could come in at what time and not come in at what time? What other person?
That was up to the court order.
You read all these court orders before this deposition, did you not?
I did read the court orders.
And you're aware that when those limitations were put in, that the court then deferred to the hospital for the specifics of everything, right?
Correct.
The court made certain general findings for the benefit of the child, but then deferred to the hospital about how to implement those, right?
Correct.
Order behind you, but you were the person in terms of when we get to the hospital's discretion on to do things, you were the person that had most day-to-day control, if you will.
I was at that point consulting with Risk, and so that would have been up to Risk to interpret, and I asked many times to have Risk interpret them for me so that we knew what we were supposed to do and not do.
Right. But the day-to-day implementation of the orders left it up to the hospital, right? Or
It
the
is
hospital's discretion, correct? You can answer.
as much as yes, as much as we could.
Okay. That discretion then, is it your testimony here that your discretion, whatever actions you implemented regarding who got to see Maya, how much they got to see him, what she ate, all of these things that involved limitations on her life while she was in there, those actually came from the risk management committee, right?
Yes.
If the father has visitation rights, who was making the decision of how, where, and when Jack Kowalski could see his daughter?
DCF.
So you were not involved in making that decision?
No.
Where are the orders from DCF?
This is it.
Okay, it says supervised. So in order to supervise, what did you understand needed to happen?
DCF had to give us somebody to supervise the visit. We don't do that.
Okay, and did they ever give you somebody to supervise the visit?
Mr. Kowalski had visits, so yes, I would assume they did.
Okay, well, how did you know who was authorized to visit and who wasn't?
So CPI would call, or somebody from the Department of Children and Families would call us.
Who made the initial call to, or either call to the hotline?
The first one was made by Debbie Hansen, and the second one was made by Lane Brown.
Debbie Hansen. And who's Debbie Hansen?
She was a social worker at the hospital.
Did you ever speak with her?
Well, yeah, I mean, she worked on a
About
team
this?
with me.
Okay, and then who was the next one? Lane Brown?
Elaine Brown,
And who was Elaine Brown?
she was their social worker on the weekend.
Did it strike you, or does it strike you at any time how serious it is to take a 9-year-old girl away from her family?
Well, yes, definitely.
How harmful that is to a child?
It can be.
Okay, so what did you understand was the reason that a shelter order was entered?
My understanding from the shelter order is that they had information from Dr. Smith and our medical records.
Okay, Dr. Smith then and JHACH medical records, right?
Yes.
As one of the people who saw Maya the most in the hospital, tell this jury what you saw with your training in.
Oh my God. You guys, I promise it's just been a long week. I promise it's just been a long week. I don't do this all the time. I promise you it's just been a long week. Oh. So you just heard Anderson make a comment about tell this jury. That's Mr. Anderson's voice. You're not going to hear defense counsel at all during this transcript. And there's good reason why. And people were asking me why play the deposition. So Mr. Anderson knew he was going to use the deposition. I don't think he ever intended to call Cathi Bedy to the stand live. And there's good reason for doing that. There's very good reason for doing that. One of the reasons why, well, several. Let me do this. Reasons why you're not going to call Cathi Bedy to the stand. One, she's going to know that she's presenting to a jury. She's going to try and appear differently. Depositions, people have their guard down. You can usually get them talking more freely, or they put on that RBF, resting bitch face. That's one reason. Two, at trial, if you call an adverse witness, when you call an adverse witness, you can get an instruction that says, I would like the opportunity to lead this witness. Usually you cannot lead your own witness. However, if the witness is an adverse party, you can say, Judge, I'd like to treat this witness as a hostile witness or an adverse witness. In that case, you can lead them, kind of like cross-examination. However, caveat, however, because you called them in direct, defense counsel gets to lead. They are still subject to the same rules of cross-examination. They can lead that witness all over the place. I would never, ever, ever in a million years want to allow Mr. Hunter, Shapiro, Hughes, anyone to lead this witness in cross-examination. Not if I'm the plaintiff. So I don't want them leading this witness. You did this because it was this. You did this because it was this. You did it because it was this. No, I don't want them doing that. So I'm going to call them in deposition. I want the deposition there. The risk of putting them on the stand and allowing Mr. Hunter, or Mr. Hughes, or Mr. Shapiro to lead this witness in cross-examination is too substantial. I want this witness on depo. I want to control the circumstances of her testimony. And I want her to kind of know that I'm controlling them, but also not have the jury there, to not realize how significant what she's saying is. She's still under oath. It doesn't change the testimony. Very, very logical. We're not going to see Cathi Bedy during this trial. I don't think. And I don't think defense is dumb enough to put her on. She has since been fired by the hospital. I don't know whether that was to kind of put her outside the reach of the hospital or what, but she no longer works there. So there's little risk or little reward, tons of risk to calling her as a live witness. Give me the depo though. The depo is great. Oh, tell this jury, will you please tell this jury that you absolutely did this? It was your own volition and you were following the orders as you interpreted them. It is astounding. I want to get to the place in time and I forget where it is. Give me 1 second. Let me try to locate it because it was, so one earlier in the testimony, she goes over her experience and he says, have you ever, diagnosed Munchausen's by proxy? And she goes, no, but I'm familiar with what it is. And Anderson says, give me five of the checklist items you have to hit for Munchausen's by proxy. And she struggles through it, stutters. It's really painful to listen to. Then what I want to get to is the photographing incident, which is, I believe, give me 1 second. 1 second, too dangerous. There's the care issue. Transfer to the Moors. Dealing with her. This is the removal action. There we go. Okay. 20812. This is something that we go into about the phone calls. We'll get to that in a second too.
I was up in her wheelchair going to activities within the hospital.
Except on the days when she complained of extraordinary pain, right?
95% of the time that I saw Maya was up in her wheelchair. And the times that she would report extraordinary pain would be when she was prompted by her mother.
Prompted by her mother.
Excuse me.
Are you finished?
You finished with the answer?
Prompted by her mother, or if somebody asked her if she was having pain. And sometimes that was in the setting of being down in the child life department has a room and activity center down on the second floor. So I do know that there were a couple of, maybe it was the guardian ad litem or the CPIs that met her down there. And while they were watching her have these activities, she was reporting her pain as being a 10.
Okay. Is it true that Ms. Kowalski wanted to record the phone calls?
Yes.
With you?
Yes.
But that you objected?
I did.
Why would you object to that?
So I think that all children's, we have a policy not to be recorded. And I was told by risk management that we weren't agreeing to be recorded in those phone calls.
Fast forward a bit. They changed the volume to 20.
Did you ever have any discussions with anyone from risk management to the effect that the Kowalski case, the Maya Kowalski case, was, and you can use whatever term you want, thorny or difficult or required?
We're going to fast forward.
And over the phone and wanted to come into court, was that she was terrified of you sitting next to her and what you would do to her? She'd be wrong?
Yes.
Okay. She just made that up, that you were sitting next to her during her court appearances.
I don't know that I was sitting next to her. I think she was with her attorney at those times.
Were you in the room?
I don't know. I don't remember being in the rooms.
Did you require Attorney Kelly to leave the door cracked while he was meeting with her?
We may have.
Why did you want to leave the door cracked while Maya was trying to consult with her attorney?
We were not in the room with her, but there had been an episode where Maya said she fell out of her wheelchair and was on the floor for hours. So at that point, it was discussed with risk management. Risk management wanted the door left open so that we could make sure to monitor the patient.
Really? So you think the attorney was going to let his client lay all over the floor and not help her? So you guys had to be there right beside her or listen in. Strike that. So the purpose of cracking the door and being right there next to it, because if, right, you were standing right next to the cracked door.
No.
Then, so we were going to be able to hear it by Maya shouting and screaming down the hall?
The door was left open so that the nurses could observe and make sure, because as they were walking by, it was not me observing. This was the nurses observing that were on the unit.
Okay, so, and the theory was that
Remember the testimony. Remember the testimony from Mr. Zimmerman.
while Maya was in the room with her attorney, there was still a chance she would fall out of the bed and her attorney would not ask for help or otherwise assist his client lying there on the floor. So you guys had to be able to look in. Is that the theory? Was that the theory here?
So risk management, after that happened, wanted to make sure that the door was left open at all times so that there was site to site so we could make sure that Maya was safe, yes.
Why would it be a big deal that she fell on the floor?
I never said that Maya could move around freely. I said that we watched her move around with her legs. What Maya could and couldn't do was not my decision or making. I saw Maya move her legs. I saw Maya move her arms. I saw Maya move her feet.
All right, so the theory then was that because Maya said she fell out of a chair once, you guys had to leave the door open or cracked so that you could see her if she fell out of the chair, right?
That's the direction that we got from risk, yes.
Okay. And so to explain to you that it was felt that the attorney would not be able or willing to help his own client if she did fall out of her chair with him there?
I can only speak to you what our direction was given, and that is that we had to leave the door open.
So it came down from risk management that Maya would not have, it was necessary to keep the door cracked, even when Maya was trying to consult with her own attorney.
Yes.
Did you ever confiscate a plastic bag filled?
All right. Fast forwarding to the next part, 24110.
Ask you to identify that, see if you know this exchange.
Yes.
And what is this about?
So I think this is I'm pretty sure this is the day that Maya was going to the courthouse and then going to see Dr. Hannah. And we were asked to take pictures.
Listen, listen, listen. We were asked to take pictures. This is the incident where she was held down, photos were taken of her. Listen.
Risk management asked you to take pictures?
So I have to go all the way back to the beginning. So
So it was 18? Yes.
Very funny, Lori. Very funny. I'm not muted. Attorneys are going back and forth. That's why it's quiet. You see the transcript going? Attorneys are going back and forth. This is an
Dr.
editing
Danielson
issue.
notes in her email about pictures. I was contacted. Patty wanted to know, is CVI able to help out? They can't. They're doing their own pictures in Sarasota. And then I indicate that I think that we should do them here at the hospital. Patty agrees. She suggests that 2 people are in the room and she has a camera.
So who's Patty?
Patty Condon is risk management.
So risk management made the decision to have these pictures taken of Maya?
Yep.
And tell me what happened. What did you do with Maya?
The bedside nurse and I went in and took pictures of her arms, her legs, her face, and her stomach.
Was she in her bra and panties?
She was in her sports bra and a pair of shorts. I think we took pictures of her back too.
Bra, and she wasn't in panties, she was in what?
Her shorts.
Who gave you guys permission? I say you guys. Who gave risk management permission to take photographs of this little girl's entire body?
So that would be, again, I was directed by risk management to do that.
Did you object in any way to this?
No, I did not.
Had you ever taken pictures of a child without any clothes but bra and shorts before? Not your own, but I mean in the professional context.
In professional context, in the foster care program, if they were going to visit a situation or when they came back, if there were injuries, yes, we did.
But she didn't have any injuries. She'd been with you for over 3 months at that point, right?
Correct.
So did anybody give you any reason why they took pictures?
I was just directed by risk management to do that.
Was there any discussion at all of why it was necessary to take pictures of this little girl in her sports bra and shorts?
Like I said, this started with Dr. Danielson and came down to me.
Who's Dr. Danielson?
Her name, Dr. Danielson, was probably the attending that day.
Okay, so this wasn't coming from the government. It wasn't coming from DCF, right?
This was coming from our institution, Dr. Danielson.
Right, not from DCF. This was an internal decision to ACH.
Yes.
What steps were taken to call the parents and ask whether you could take pictures of their child like this?
We didn't call we didn't call the parents
Why not?
because at the time the child was in the custody of DCF and they gave their permission.
How did DCF give permission for you to take pictures of this little girl in her sports bra and shorts?
So they were getting ready to do their own pictures.
Who was?
DCF. They did their own pictures in Sarasota.
So why was it necessary for you to do pictures?
I can only speak to you to what I was asked to do.
They didn't tell you why. They just said do it.
Yeah, pretty much.
Well, pretty much.
Yes. The direction was to do the pictures.
Was Maya upset?
Yes.
She did not want you to take pictures of her like that, did she?
She did not.
This part's tough.
But you went ahead and took pictures of her anyway.
Unfortunately, we did.
Was there an issue over scratches that Maya had on her?
Yes. So
There's a poll in the chat. There's a poll in the chat. Please participate in the poll. I'm almost without words. I am almost without words. This entire deposition was a cluster funny business. She waffles back and forth over whether she took them, suggested them, etc. Usually, let me take this down. Usually, depositions are the most boring part of any trial because you don't get live testimony. That is usually the case. Usually. Have I said usually enough? I rewatched this thing twice, this full depo twice. I watched the last question in the previous depo like 3 or 4 times, like 7 by now, to be honest. This is how you end a week. This is how you end a week of trial because now the jury goes on a long break. The jury is going to be out from the end of today until Tuesday when they resume. Wow. This is how you end a week of trial. What an absolute nightmare for the defense. Because regardless of whether the defense says that the DCF instructions were there, you now have to assess the credibility of Cathi Bedy. And I want to get to the afternoon session real quick, and I'm going to recap it as best I can. I want to get to the arguments more so than anything else. Because, yes, the jury asked questions, and the judge says, unfortunately, I can't answer those questions right now. I will give you instruction about the orders. They want to see the orders real bad. They want those orders immediately. The afternoon is attorneys only, jury is gone. In the afternoon, they're going back and forth over what exhibits they want to introduce and how they want things to be read. The beginning part of the afternoon, I'll just summarize. There's a bunch of statements that Maya makes that she puts in notes or in captions or in little comments that are recalled by others. This would typically be hearsay, not admissible and not subject to exception, unless it was present sense impression, non-hearsay. If it's non-hearsay, you can bring it in for limited purposes. But Florida has a statute. It's called the CA hearsay exception, basically hearsay exception, where if you meet the different criterion, which is a child that reports the statement, makes the statement in a of alleged abuse, and that statement is recalled in that moment, and it's sufficiently reliable, the recollection is sufficiently reliable, it can overcome that, and it can come in for the truth of the statement. What that means is that if Maya writes a note that says, I was force-fed on this particular day, it's not just suggesting that might just show how she felt that day. No, that statement would come in as substantive evidence. That would come in for the truth of the statement written on that piece of paper. It was a big argument. The judge ends up siding and says, this is coming in. So defense was not happy about that. They fought about it quite a bit. Then we get to a lot of the argument in the afternoon over the various things that are introduced. And let me go ahead and start with, let's go here. And forgive me, I might bump around a little bit during this one because I don't want to run too late. I did push FNF to 8:45, but I want to get a moment to have a bite of food before I start my evening stream. So we're going to start. Make sure wait, hang on. Boost the volume, Rob. Volume boosted. On. Closed captions. So move the closed captions so that we can see them. Present the screen. There we go. Put up the little thing that says that we're doing motions and argument. There we go. Let's go.
Tony is she had the authority, then this email should not come in.
I already said that to me, this email should not come in.
Okay, sorry.
I said that 20 minutes ago.
Yes, you did, sir. I'm sorry.
But I wanted to be clear because I've seen this issue now as to where I thought this whole thing's going to go. And I was alerting Mr. Altenburn to the possible jury instruction that I'm envisioning is going to have to be given.
I understood, Your Honor. I'm trying to alert you to where I think it's going to go. And this is the first step in a long path.
Well, maybe we can agree to disagree at this point.
Currently, the email is not coming into evidence.
We're the
Oh,
ones that have.
time out. Only one at a time. It's Mr. Altenburn's turn.
The email currently is not coming into evidence. Is that right?
Correct.
Okay.
But I'm telling you that the issue of authority, because I know I've already talked to you about wanting to do an instruction that talks about the visitation and the dates and the times, and I can see that being a specific issue that the jury is going to have to make a factual finding on. What's next?
Oh, dang it. We're a little fast. Hang on.
Okay,
Back this up a second.
Long path.
But I if we are ever going to get to number 3 on it, as of December,
Here we go. This is what the judge is saying.
Conduct that would have a finding of outrage or damages. But if the answer to that is no, then I think it's fair game. And so I think the evidence for that is whether or not DCF authorized Miss Bedy. That sounds like a pretty limited scope of testimony as opposed to what happened later on in front of Judge Harris. That I don't want to get into. And I don't think you need to get into that. I think you just need to get into, as of December 10th, or sorry, on November 10th, this is what the court order said. And it clearly doesn't give the hospital the right that you think it does. And it's a question of fact as to whether there was a delegation.
Judge, what I'm suggesting to you is that is not the only issue like this that the court's going to be confronted with.
Well, this is issue number 1 on this sheet that we're now 40 minutes into, and I don't think I'm changing my mind on this right this second.
I would urge Your Honor to consider it. That's all.
Judge, can I?
Folks, if we are ever going to get to.
Let me tell you why the judge is frustrated and why they're pushing the point so hard. This argument right now is over Chapter 39 immunity. Whether or not the hospital is immune for these actions because they're operating as a delegate of DCF. And this is a big thing the hospital has been standing behind. What they have said is that the tasks that Ms. Bedy was doing, what she was doing was done at the instruction of DCF and in conformity with the order. And therefore, we shouldn't be litigating this at all. What the judge is saying is that the way the judge has, for those of you who think the judge is not fair, the fact that it's going to trial is amazing. It's amazing. What the judge is saying is that the issue of whether Ms. Bedy was acting in conformity with the order is an issue of fact that I have to put to the jury. The jury gets to decide that. That is massive. That is massive. What the defense is trying to do here is they're saying, we're not going to relitigate the entire dependency action because a lot of the stuff was in there. And the judge starts going back to the order and says, the order says that DCF is going to monitor the calls. Where in the order does it say that Ms. Bedy is allowed to monitor the calls? And then the defense says, well, DCF tasked her with that. And the judge says, and that's an issue of fact for the jury to determine. This is the ball game right here. This is the ball game over whether the plaintiffs can prove that the actions undertaken by the hospital were in conformity with the orders, or whether they were outside the scope of the orders and the hospital was acting independently as an independent actor, not protected by the immunity. This is the big part. This is the huge part of this trial. And the judge has just kind of telegraphed how the judge is viewing it. The orders were there. Now you want to hide behind Ms. Bedy's interpretation of the orders or the hospital's interpretation of the orders and say that that interpretation was given judicial sanction, but the orders don't say that. This is now a question for the jury. You can see why the defense hates it and why the plaintiffs push so hard. That was a massive win. That's a massive win for the plaintiffs. And let me explain why with one example, then we're going to get to super chats. 247. Here we go. This is audio that you're going to hear of Cathi Bedy monitoring phone calls.
Audio.
I've got it to his.
We're perfect. I was just letting you know that was the delay. I had to switch it back.
Oh, okay.
I was doing it privately. May I publish?
Yes.
Okay, I'm recording this phone call so everybody knows. Okay, hi mommy. Hi honey, how are you, sweetie pie? I'm hurting, I miss you. I miss you so much too. I miss you so much every day. Every single day. You know how happy it makes me feel to hear your voice. Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah. I hope you. What did you say, sweetie? I hope I can see you soon. I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay? Yes.
We're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Is that the conclusion of the clip?
Yes, sir. Yes.
Okay.
That comes in.
Has removed consent.
They double check.
And you can
And
play
listen
Diaz
to
and
make sure the
Bravo.
consent wasn't removed.
How you doing? How is PT and OT going for you? Not good. Why is it?
Okay, Bianna, we can't discuss any of those type of matters, okay?
Okay.
Is that the conclusion of Bravo?
Yes.
All right, that's where I'm going to end it. Those get played. Defense didn't want them played because defense wanted to hide Well, defense wanted to basically make the argument that those couldn't be played because that was already litigated in the dependency action. The judge has said, no, the jury gets to decide. And what the judge said very specifically, clarify, because people are asking about directed verdict. What the judge said very, very specifically was that if the plaintiffs are making a proffer, a suggestion that evidence will produce and prove this, that Cathi Bedy was not acting in conformity with a valid DCF delegation. If they say that to the jury, if they suggest it to the jury, and evidence develops at trial that she was, and that evidence is unrefuted, all you need is one piece of evidence that says she was delegated authority and that evidence being unrefuted, then that is a directed verdict for the defendants. If DCF does a valid delegation of authority, and that doesn't get refuted by any other evidence, defendants get a directed verdict on that charge. Not only that, but the judge is going to give a very, 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 very strong and harsh instruction to the jury that they are to disregard a lot of what the plaintiffs have been saying. So what the judge is doing is the judge is basically saying, plaintiffs, this is your case. You're telling me there's evidence. I'm going to let you develop this. But please be aware that when you're walking down this path, if the evidence doesn't play out the way that you're suggesting, it's going to cut very hard against you. And in a way that's going to be very damaging. So that's where we are at the end of the day. Got a bunch of videos that are coming in. And that's kind of where everything stands. I want to hit super chats real quick, and then we're going to wrap. And I'm going to go to FNF. I might have to push it to 9 at this point because I want to make sure I get to your guys' questions. Let's go ahead and remove the banner as well. Lavisa Johansson, not sure if it's a mistake. If defendants going with the Munchausen's used suicide stigma to show B's priority was B. She didn't care if she would hurt M. I've seen it. It's just the question is very brutal, very brutal. That's it's the question. It's the judgment of whether or not to ask the question. Luann Huth, hope she lost privileges to work in this capacity. I don't know that she is right now. Valerie, just following orders, so familiar. Kind of. SF, Rob, grab your F-bombs. I needed the real things. Just because, thank you. So I assume there's a lot of documentation admitted through this deposition that is from risk management that includes these instructions. Not that we've seen. We'll see. Nikki Lewis, thank you. Anderson's on fire with this. Hope he brings us back. He did great during that depo. Happy Hippie. Betty's testimony changed my opinion of the case. JHACH is liable, in my opinion, before I was on the fence, but in my opinion, this is the worst, most damning testimony. It was really, really bad. Island, when do we hear from risk management? They're responsible for a lot, according to the witnesses. I'm very curious. That's going to come into the defense's case. I'm waiting to see. Like I said, the judge gave a very, very firm directive that said if there was a proper delegation, then that's going to be very bad for the plaintiffs. We're going to have to see if that comes out. Snazzy Trinkets, thank you. Note how she cannot remember where she was or what she was doing, but she can good recall what Mom and Maya said or was doing at the given time. That depo was disastrous. Celebrial, this woman's never been in chronic pain. I don't know. In my humble opinion, when she comments that Maya wasn't in pain because she did things, I wanted to scream. Yeah, she said Maya was, that was tough. Listen to that depo at your discretion. Crazy by proxy, happy FNF. Thank you. Ryan Man YYC, please schedule a meeting for the boo box for yourself. Yeah, for the muting. Yeah, thank you. Horse welfare. I'm a victim of blatant medical malpractice. Blaming and attacking the victims is a very common strategy utilized by the defense. I experienced it. I'm very sorry to hear that. I know a lot of people that are on the bad end of these types of decisions, and I represent a lot of them. So that's why this is important to me to explain that what you guys are hearing from a big institution, institutions are the very best at covering they're the best at ignoring things and covering and creating narratives that cover it. Now, it doesn't mean it happens all the time, but it does happen. Morgan, thank you. Love watching your recaps. Thanks for being here, my friend. AEG, I got the best news today. My first choice contracting company for transcription offered me an interview celebrating with the community. AG, congratulations very much. I hope you very much enjoy the job. You're going to hear a lot. You're going to hear a whole lot Retired Nan, I'm getting this in early. When the social worker is confronted about a recorded call she did not know was recorded since mom was told not to record, I believe she would have lied, but she was caught. Mom announced the call was being recorded. Mark, get a sticky note to remind you of your mic. We need to do that. Kelly Waller, question: Why cannot Bedy be compelled to testify in this trial? I think I answered that one. Matt Bond, good day, spiffy legal mumbo jumbo talkie brother from another mother. Matt, I love every single time you tell me that. Every single time you've been an ever-present force in the chat. I very much appreciate your take on a lot of this. I know that you suffer from CRPS yourself, and I know it's been very taxing on you. So I'm very glad to see you here and hope you're doing well, my friend. Make sure I get this. Thank you, Matt, for being in the chat. Brady Rose, thank you. How do you feel about this judge? Maybe I've been spoiled by Judge A and Judge Newman, but he seems quite impatient. Thank you for coming to the case. He has exponential patience. This is a case he has had for years. He knows the facts backwards, forwards, left, right, center. I think he's done a phenomenal job navigating what is a complete clusterfuck of opinions. It is wild. It is wild how difficult it is to get this case all the way to trial. To those of you guys who gifted memberships tonight, thank you very much. Roro, thank you. Joshua, thank you. Ryan Man YYC, thank you. Lori Liani, thank you. Ange Torres, thank you. Ending the chat, or ending the poll that I put up earlier. 1,211 votes. What was the most impactful moment from day 9? Cathi Bedy's whole deposition or the final questions from Ms. Johnson? 84% of you, with 1,200 of you voting, said Cathi Bedy's whole deposition. So, yeah. Monday. Mark your calendars. Monday. Maya Kowalski is going to take the stand. So, we're probably going to take a little bit extra time dealing with that. And we're going to do our very best to walk through it. Thank you guys for being here. I'm going to go ahead and leave FNF up at 8:45. You guys can be redirected there. I might be a few minutes late. Please don't be too mad at me for that. I am just going to grab a quick bite and I'll be there in just a second. Love all of you guys being here. Thank you for letting me recap this trial. Thank you for appreciating the subject matter that we're discussing and the sensitivity thereof. If you wouldn't mind, please like the stream itself so that people do get directed to that stream. And please, Laura, this is a remarkable point. Hang on, Monday or Tuesday? Take a look at my socials. I'm going to post to confirm. I want to double check. I'm going to post to confirm. I think it's the first day the court is back. I don't know if the court is back on Monday or Tuesday. It's the first day the court's back. I will double check. I will post it here on YouTube. If you guys want a reminder or notification, please subscribe to the channel or consider subscribing. I do these recaps every day. We will see. Yeah, I thought the judge said Monday too. I thought the judge said Monday. I don't know if Florida has that day off. I think this next week in Florida, it's Monday. I think it's in Monday. I want to be like 90% sure. So yeah, please like the stream. Please consider subscribing. I'd like doing these recaps and I like you guys being here. On that, I'm going to make a judgment call. I'm going to push the stream to 8:50 just because I don't want people waiting there unnecessarily for FNF. But go there. If you want a notification for when I go live, hit that little bell. The second that I hit the live button, you will be notified that I am live. Again, very much appreciate you guys. Thank you for being here. Love all that you guys do for the channel and contribute to the ongoing coverage. So good night, all. Hopefully, I'll see you in a minute.